Assalamualaikum and a very good day to everyone and our beloved lecturer Dr. Muharis bin Mohamed. We are from Group C from Class A and we would like to present about duty of care to provide safe premises.
Assalamualaikum and a very good day to everyone. My name is Izian Laila Liana binti Ahmad Zamri. My matric number is 275631. First and foremost, in Malaysia, the principal legislation that deals with employment, health and safety is the Occupational Safety and Health Act 1994, which is OSHA. This responsibility exists with an employer's common law duty to have a safety and health of working environment. Apart from OSHA, other laws such as the Employee Social Security Act 1969, which is GHOU, it provides for employees' compensation in the event of employment injury. Occupational Safety and Health Act 1994, which is OSHA, it imposes a statutory obligation on all employers to ensure safety, health, and welfare in the workplace. A duty of care is a legal obligation imposed on an individual that requires them to follow a level of reasonable care when performing any actions that could hurt others in the future. It is the first factor that must be demonstrated before a negligence lawsuit may be pursued. It defines the general duties of employers, employees, self-employer, designers, manufacturers, importers, and suppliers of plant or substance. The National Council for Occupational Safety and Health (NCOSH) was set up by the government. It is an organization that promotes safety and health in the industry. This care of duty includes the physical and mental health of the employee. The standards of care are determined by reasonableness requirements. It requires the employer to assess the potential risk of injury as against the harm that would cause the employee the cost of taking safety measure. Next is the greater the risk, the greater the level of care required of the employer. However, the employer does not have to provide a workplace that is absolutely safe, but rather reduce any risk so far as is reasonable. Next is the advantages of this act. All workplaces have a legal obligation to ensure that employees, volunteers, students, businessmen, or the public are fully protected from any personal and physical or emotional danger. Firstly, the individuals receive proper training. The organization can promote good practice, reduce risk, eliminate ignorance, and create and maintain a safe environment. This act is reinforced when one considers that the objective of OSHA is to protect and ensure the safety and welfare of people in the workplace and people who work at other places such as assigned abroad. Another important law that protects employees while working is the Employee Social Security Act 1969. It provides for social security for the possibility of employee injury in favor of the employee. Under the Act, employees are entitled to claim the certain benefits such as medical benefit, disablement benefit, constant attendance allowance, dependence benefit, funeral benefit, survival pension, and invalidity pension. Last but not least, the Employment Injury Scheme under GHOU provides protection to employees against occupational injuries including occupational diseases and commuting accidents. GHOU operates under the no-fault principle. To make a claim under GHOU for compensation, all the employee has to do is prove that he or she has suffered an occupational injury while working. There is no need to prove guilt on either side. Accidents that occur during an employee's employment are considered as a result of the employment. Similarly, an accident that occurs while an employee is going to or from his or her place of work is considered to be while working. Broadly speaking, this also occurs when workers travel abroad to work because no decision is made about workers going to work domestically or to foreign countries. Next, I will pass to my friends to elaborate more about this topic.
Hello everyone, my name is Kalisa Atira binti Muhammad Shafiq and my matric number is 275484. Duty of care is the standard of care required to ensure that the premises are reasonably safe for the intended purpose, where a person pays to enter premises either for the purpose of occupying it or for the purpose of a particular activity. Furthermore, the occupier's liability definition is the concerns of liability of an occupier to persons who are injured on his premises. Thus, when it is established that a person has sufficient control over the premise, he is deemed to be the occupier. As for entrance, there are 4 types of entrance mentioned by Per Swee Chin SCJ in Datuk Bandar, Dewan Bandaraya, Kuala Lumpur against Ong Kok Peng and Anor, each with a duty of care owed. There are 4 types of entrance, which is the contractual entrance, invitees, licensees, and lastly, trespassers. Contractual entrance arises from an agreement or contract between the parties and is based on contractual rights, and the highest duty of care is owed to contractual entrance. Contractual entrance has 2 types, which is the first one is main purpose entrance and the second one is ancillary purpose entrance. Next is invitees. Invitees is an individual who enters the occupier's premises with his permission in order to pursue a mutual interest with him. And there are 2 types of invitees. The first one is legally authorized entrant and the second one is business visitors or associates. The third type of entrance is licensees. Licensees is an individual who is on the premises with the permission of the occupier for a reason in which the occupier has no interest. And there are 3 types of licensees. First is those entering as of right. Second is those entering by implied permission. And lastly, those entering as mere social visitor. Meanwhile, trespassers are an individual who occupies a premises without the owner's express or implied permission and whose existence is either unknown to the proprietor or, if recognized, is objected to and is considered trespassing. The first case that I am going to share is McLennan against Sega, 1917. In this case, a fire broke out at the defendant's hotel and the plaintiff was injured while he was trying to escape from the 2nd floor of the building. The court found the defendant liable for failing to ensure that the premises was safe for habitation as there was no emergency way out. McCarty J said that when an occupier for a reward agrees that another person will have the right to enter and use the premises for an agreed purpose, then the agreement contains an implied warranty that the premises would be safe for that purpose as far as can be reasonably expected. This principle is limited as the defendant cannot be held liable for defects to the construction, alteration, repair or maintenance that cannot be reasonably discovered. The court held the defendants liable for the injury that the plaintiff suffered during a fire as they failed to ensure the safety of the guests by not having an emergency exit in the hotel. The next case is the case of Sri Inai Pulau Pinang Sdn Bhd against Yong Yit Sui, 1998. In this case, Defendant 1, a school, has rented an old dwelling house from Defendant 2, which is a local authority, for a period of 3 years. Defendant 1 used the premises as a hostel to accommodate its students. At the commencement and during the tenancy, Defendant 2 did not make available safety exit for occupants in the event of fire. And this was in fact a direct non-compliance with the Uniform Building Bylaws 1986. However, a fire broke out and resulting in several deaths and serious injuries to many others. Thus, the Sessions Court judge found both Defendant 1 and Defendant 2 equally liable. the High Court found that as a matter of law, defendant 2 could not be liable whether as a landlord or a local authority, and so defendant 1 was found solely liable. However, defendant 1 appealed. The Court of Appeal set aside the order of the High Court and restored the order of the Sessions Court. Defendant 2 was not a bare landlord. It had a duty to comply with the bylaws, which it did not. It was well aware that the premises would be used as a hostel for young children. It had exposed the plaintiffs to the risk of injury knowingly. Therefore, once it is established that a person has sufficient control over the premises, he is deemed to be the occupier and may be sued for any injury sustained on the premises.
Assalamualaikum, my name is Muhammad Azwan bin Azman, matric number 267824. Next is the recommendation. First is utility. A fresh and clean safety kit should be provided for housekeeping department to protect them while handling chemical to finish their job. Things such as rubber glove, mask and apron. This item not only the housekeeping department will use, but also the kitchen department, pool worker and chambermaid. Okay, next is monitoring the workload. A welfare of worker also can be improved by monitoring the workload, environment, working pattern that include stress and depression. A lot of people today do not take mental welfare of other people seriously. By applying the duty care of law about welfare of employee, the work environment will be much effective that can be benefit to the company. The last part is safe premise and training. In building and premise sector, training for staff such as minor fire hazard should be compulsory. A hotel can train their staff to handle this situation to ensure the safety of staff and guests in case it happens. Providing safe route of entry and exit, ensuring equipment is installed and used correctly such as fire extinguisher, and providing protective gear equipment can help staff to handle the particular hazard without putting them in danger based on OSHA Act 1994 Safety and Health Act. And today we're going to talk about the conclusion duty of care. Duty of care to provide a safe premise in hospitality industry should not be cast aside of importance of staff safety and health. Well-being of staff is an important aspect of job satisfaction and motivation for staff, which influence a level of effectiveness in completing their tasks. Worker safety should not be priority in finishing daily tasks. This concern cannot be taken lightly. When employer is unable to fulfill function, the company overall priorities will decline. Co-worker may temporarily assume additional responsibility, which will lead to negative impact on the time and focus they have made for their own scope of job responsibility. Therefore, Malaysia employers should take reasonable measurement to ensure the safety of their worker to minimize the possibility of civil crime penalties under the relevant legislation law.
That's all from us. Thank you for lending your ears and time. Stay safe.